We are gonna go
Sorry.
we're gonna go through the health and safety module today. And it's uh, it's a little more factual than you're probably accustomed to, at least in the first four modules you've gone to. There is information-based learning that you're probably going to want to go through and make sure you remember. The information will cover the questions on the CPC. So we'll make sure to address those points. I'm not going to raise awareness, but like the information is available there. If you have any questions during the course of the presentation, by all means, raise your hand. Sometimes I won't see you if you virtually raise your hand. Just unmute yourself and you can speak at that time, okay? And I am going to stop my video once the presentation goes on. Can anyone confirm that you're only seeing the slide deck and not anything with notes?
It's just the cover page, the
Just
health
says
and
health and safety.
safety. Yeah.
Okay, very good. We're having some issues before the presentation. That's why we were delayed. So, with that, we'll get started. I'm going to shut off my video just because I do find it kind of distracting. Okay, so the CPC certification, as this is the last module, we've probably already gone through this. There's six modules now. You have to do five out of six modules. Legal aspects, health and safety, legal aspects of recruitment selection, business ethics, practice and ethics. And part of and then you have the challenge exam. And one of the important things with the CPC certification program, and something that we promote in our business, the reason we promote it with our staff is because it is an education and certification program put on by the industry itself. So it is sponsored by ACSESS. The speakers who you've had the privilege of listening to already are long-standing temporary and employment agency professionals. They know exactly what you're going through. They understand the nuances of the industry, the challenges that we face, as well as the specifics that we need to be successful as we're going through the CPC program. The ACSESS mission statement, I'm pretty sure you've probably already gone through this in a couple of the other modules, so we will skip it. The ACSESS Code of Ethics, that is something that we as companies supporting ACSESS and signing up to be a member of ACSESS, it is something that we adhere to. It is a condition of being an ACSESS member, a paying temporary employment agency with ACSESS as a national body. And as we go through this, we didn't really do an introduction. I'll tell you who I am. My name is Dave Wells. I do health and safety on a national level and have been doing so for over 2 decades now, all in the temporary and employment world. So I have been involved with this. I've been teaching this class for probably about 12 years now. And again, one of the values I find from it is being able to explain how our industry is a little bit different. If you go to any sort of other health and safety course, you're going to find some of it doesn't really apply to the business that you're in, the industry that you're in. So the idea today is we're going to go through health and safety with the mindset of approaching it from the temporary employment agency world and some of the issues and nuances that we do have as we go through it. We do have some learning objectives today. We're going to be going through a number of topics. We're going to be looking at safety principles and risk management. We're going to be looking at specific legislation in terms of health and safety, and those include the Occupational Health and Safety Act, WHMIS, critical injury, some of the workers' compensation areas. We're going to be looking at rights and responsibilities, including managers, supervisors, workers. We're going to be looking at some hazard recognition and control measures. We're going to be looking at some issues with regards to workplace inspections and accident investigation. And overall, we're going to be looking at developing and implementing effective workplace programs. Now, by all means, this course today is only a couple hours. It will be 2 to 3 hours, depending on how fast we get through some of the content. But it's not supposed to make you an expert in health and safety. What it is supposed to give you an overview of the information that is relevant to health and safety in terms of being an employer within whatever province you work for. There is going to be a specific eye, a little bit more to Ontario sort of terminology. but I will draw attention to that in case there are any members here today that aren't Ontario based. And upon completion of the course, you're going to be able to do a few things. You're going to be able to find the applicable occupational health and legislation, just be able to recognize that it may exist and where to find it. And if you know where to find it, then you're able to reference it in case of having to educate yourself on that piece of legislation. You're going to know your health and safety responsibilities. You're going to determine ways of meeting your occupational health and safety responsibilities as well. We're going to take a look at hazards. So you're going to be able to identify some of the hazards in the workplace and develop safe work practices for the same. We're going to understand consequences of non-compliance with regards to legislation and dealing with the government in terms of health and safety. And we're going to look at the idea of what due diligence is. Due diligence is basically the cornerstone of occupational health and safety legislation. And what it does is demonstrate what the minimum level of need for education and training and compliance as an employer operating in any one of Canada's jurisdictions. So to begin, we're going to start with the Occupational Health and Safety Act. As we go through this today, at approximately the 1 hour mark, about halfway through the presentation, we will take a 5-minute break just so everyone can stand up and stretch or go to the washroom, check your email. So the break will come, and again, it'll probably be at about the 1 hour, 1 hour and 15-minute mark. So we're going to start with case study. The presentation today has 4 case studies. I will read the case study and ask you a few questions. If you can, record the information in the chat function of the presentation, and then we will go through that as we proceed. So in this case, this is a case study in Saskatchewan, 2015. It involves an 18-year-old worker who'd been on the job for 6 or 7 hours. They fell at least 20 feet and broke their wrist and 2 vertebrae. He had been involved in working on roof trusses that were 20 to 25 feet off the ground. He had not received any training, and there was no fall protection equipment provided. The customer tried to blame the worker's fall on his untied boots. So let's pretend you're the staffing agency supplying to this particular client, and you work in a company that has placed the worker. Take a minute and note 3 things that you would have done to prevent this event from happening. So just quickly put your answer in the chat function, and we'll go through it in a moment. So great. Some of the answers coming through are very relevant to this particular case. And what they touch on is the training or lack of training therefore provided. The first thing I would look at is the worker is working at a height. So in Canada, in every jurisdiction, if you're working at a height generally above 10 feet, you do require specialized training with regards to fall protection. So you need the training, and then you will need the equipment protection in place. We know this because he fell at least 20 feet, so he was above that 10-foot threshold. So we'd really want to find out whether that person was adequately trained for working at heights, legislation and training. The second part was the age of the employee. So the worker is listed as 18 years old. And in most provinces, Ontario specifically has a designation for that. We call them new or young workers. And the idea is workers under the age of 25 as young workers or new workers who may be new to the country of Canada itself. So they may not have the pre-existing training or the knowledge or the experience of working in a Canadian workforce. And the government views those two things as essentially the same. You're looking at a section of the workforce who has less training, less experience, and may not quite understand all the rights and responsibilities of a worker in Ontario. So would we even consider this as a client? Probably not, taking a look at this from the overview. Now, despite that, the fact the customer tried to blame the worker's fall on his untied boots, based on the scenario, we know the person wasn't adequately trained. It's unclear what sort of onboarding this person has acquired, what sort of health and safety training they've seen. Was there any sort of work inspection or risk analysis or site inspection? Anyone involved with access for any length of time will have some sort of process or be aware of that process. Again, called a risk analysis or a site inspection or a risk inspection. Each company has their own sort of name for that. But essentially what that is an inspection of the client to ensure that the client is a safe partner in health and safety for our employees as we enter into a contractual obligation with that client themselves. Ultimately, as we look at this as a temporary employment agency, we wouldn't take this on as a client generally. And the idea is sometimes doing business with a client when there is a very serious injury will ultimately cost you more money than any sort of placement that you had with the customer, let alone the humanistic side of this, where this person is probably seriously injured, critically injured, and there are repercussions. And we'll kind of go through this as the presentation goes on today, and we will see what sort of issues we may have if we are not operating with safe clients as well. So taking a look at OSA and regulations, legislation in Canada outlines general rights and responsibilities. So these are the baseline occupational health and safety requirements for an employer operating in a Canadian jurisdiction. And they would cover a number of information points. It would cover women's critical injury, designated substances, industrial establishments, first aid. All of those things are covered within the legislation within each of the jurisdictions. In Canada, there are 14 jurisdictions. What do I mean by that? There's a federal jurisdiction, so anyone working for a national company, a federal company. There's 10 provincial, and there's 10 territorial. Each one of these jurisdictions has its own health and safety legislation. Now, why is that important for temporary employment agencies? It matters where the customer and therefore the employee is located when they are doing the work. So you are able to supply workers to another jurisdiction. So if you live in Ontario, you could supply to Quebec or PEI or Alberta. All those things you're able to supply to, but because of the work location, you have to understand you're beholden to the rules and the legislation of where the worker is actually performing the working duties. Federal legislation is an important one, and what it means is even if they are working in Ontario, if your client is federally regulated, you have to ensure that the health and safety rules of a federally regulated company are upheld and maintained, whether it's you're the one doing it or the customer themselves. So ask yourself, is the client federally or provincially regulated? It makes a big difference. And what sort of clients are federally regulated? Well, approximately 10% of the Canadian workforce falls under the federal government designation of being federally regulated. And these can include airports, banks, various tunnels and bridges, radio and television broadcasting, cable systems, grain elevators, highway transport, pipelines, railways, shipping and shipping services, telephone and telegraph systems. And if I were to summarize it, what that means, if a client is essentially operating across provincial lines, so if they're driving a truck, let's say from one province through two other provinces, you're going to want to ask if that customer is federally regulated. If you're supplying workers to a bank or some sort of radio, television, Comcast company, you are going to want to ask the customer themselves and make sure that if they are federally regulated, you as the agency are able to appropriately deal with the requirements of the federal regulation. OSEC aims to do a few things. Ensure employees' health and safety and well-being in the workplace. We want to encourage employees participating in maintaining and improving health and safety. We want to prevent risks to health and safety in the workplace. We want to make sure that employees are involved through representation on committees. We want to ensure expert advice and resources are available. Your role is to participate in health and safety meetings and committees, onboard and train contract and temporary employees under their OSHA regulations, maintain and improve existing training opportunities, ensure on-site health and safety inspections reviews are done on a regular basis. And this starts to delve into what the responsibilities are of us as the employer of the workers. We have a multiple choice question here, so please, I'm going to read it, enter your answer in the chat box, and we'll discuss. I complete a workplace safety and site inspection with every new customer prior to sending an employee out to work on the assignment. So that was the risk analysis or site inspection or client inspection, whatever your company calls it. So when do you do this? Do you do this all the time? Do you do this 90% of the time, half the time? Usually after they start working, I'll book a time to go on site. None of the time as my employee tells me whether it's safe or not. So can you please record your answer and we'll discuss. So the answer's coming in. We have A all the time with no exceptions. We have a C, usually about half the time. So we kind of have a little bit of a variance here. The idea is to understand that the site inspection is one of the core components of health and safety for us in our industry. The idea is we don't know the client's workplace until we have seen it, until we've inspected it, until we've done an analysis whether or not that place is safe. And the general consensus in our industry is a best practice is to conduct these site inspections to ensure that the place where you're sending workers is safe, to ensure that the client has an established health and safety management system, basically to ensure that any worker you send to work at that client is going to return home safe and injury-free at the end of the day. And that's a best practice that's been developed through provincial arrangements with government and health and safety associations and ACSESS over the years. We've developed that as something that has merit and helps to ensure that our workers, whatever you may call them in your particular company, but our workers are safe as they go out to temporary work assignments. So who's responsible for what? Again, we keep talking about the special conditions we have as temporary employment agency working with clients. And in this case, we have essentially four partners rather. We have workers, we have the customer, we have the supervisor, and we have the staffing agency. And each one of these entities plays a part in health and safety in our industry, in our arrangements. Because of this unique relationship that we have regarding health and safety, there's essentially an intersection where these four parties must come together for the overall protection of the workers. So every one of us has responsibilities. We want to ensure that this intersection is where the employee themselves are. All the bases are covered, all the training is covered, the onboarding necessary to ensure the health and safety of the person is covered, as well as all the other things, employment standards and other issues. We want to make sure that it's very clear who's doing what in terms of protecting worker safety. And the best way to do that is to ensure that your corporate contract, whatever it may look like for your particular company, so that's the contract you have between your company and your clients themselves, spells this out. So you may want to have a section on regarding health and safety, regarding training, specifying who's doing what within that arrangement. What you don't want are gaps in that program. You don't want to assume that your client is performing WMIS and you don't perform WMIS training or onboarding at all. And then there is an incident or an injury and the government is called in. They will ask who is doing the training. So again, it's ideal the communication is set forth at the beginning when you're dealing with the customer. And it's even better if it's actually signed off on and part of your commercial contract. We have another multiple choice. So who advises workers of hazards in the workplace and their specific role and provides written instruction where prescribed? Is it the customer? Is it the worker, the staffing agency, or the supervisor? Please go ahead and record your answer and we will discuss. So it appears that the overwhelming answer seems to be C, the staffing agency. Now, this is one of those trick questions. Yeah, absolutely. Staffing agency is responsible for this. The customer is responsible as well. But in terms of occupational health and safety, the person with this responsibility is the supervisor. And who is the supervisor? Is it the person at the client work site? Is it a member of your staff? The answer under health and safety rules is it's both. The agency has a person who is telling the person where to go, telling them the safety rules, prescribing some sort of training, usually we do WMIS training, and disciplining the person if there is any sort of safety infraction. The client themselves have a responsibility. They have a supervisor on site. Depending on the size, they may have many supervisors on site. The term supervisor is a very special term in terms of occupational health and safety. And we'll get into exactly what it means a few slides from here. But the best answer here is the supervisor, and that includes both the supervisor at the client as well as one of our internal members or multiple members. So looking at responsibilities, we're going to take a look at the customers first. So what are the responsibilities of our customers? Well, they have to make sure that the equipment, materials, and protective devices are provided, maintained, and used as prescribed in the workplace. So they have to make sure that any tools or machines or the workplace themselves are maintained, safe, and in proper upkeep. There has to be a copy of OSA posted in the workplace. So that's a little green book that you've probably seen, hopefully in your workplace or in one of your clients. You have to make sure that information, instruction, supervision is provided to all workers. The customer must assign a competent person when selecting a supervisor. And interesting enough, the word competent is spelled out in the occupational health and safety, but it isn't actually ascribed to any sort of, there's no definition of what competency may mean. So competency in terms of health and safety is of the employer's responsibility to determine. So it means a person through knowledge, skills, or abilities, previous work experience, that they are able to lead other people and do so safely. So the government doesn't actually say what a competent person is. The customer, the client, the agency, whoever is the employer, has to have some internal parameters, some internal guidelines by which they deem a person to be competent. Customer must have in place a written, annually reviewed health and safety policy program, have it posted and implemented in the workplace. Customer has to take every precaution reasonable in all circumstances for the protection of workers. So that's another very important term. Every precaution reasonable in all circumstances. Anytime there is an occupational health and safety injury and the Ministry of Labor get involved or the government themselves, the government inspectors, in Ontario, that's the sort of one of the charges that are often levied. The employer did not take every precaution reasonable in all circumstances. Again, the Occupational Health and Safety Act is silent on what that means. It is up to the employer to say, these are the steps we've taken. These are the safety parameters we've done. This is the training we've done. These are the procedures that we have in place at this particular machine. And we believe those are safe and we've done every precaution reasonable to protect people. Oftentimes, the government will charge an employer with that. They may deem it for whatever reason you didn't take every precaution reasonable. And then if you have to defend yourself in court, you're gonna have to say I took step A, B, C, D, E, and F to ensure the safety of the people. So it is a very interesting thing, and it's used fairly judiciously in occupational health and safety charges and lawsuits and so forth. Um, as basically the groundwork for a safety program. What are the responsibilities of the Joint Health and Safety Committee? Um, Joint Health and Safety Committees, it's required in every jurisdiction. The actual makeup of it varies, but there are some very strong similarities across all the jurisdictions. Joint Health and Safety Committees have to identify and evaluate work hazards. They have to participate in programs that protect health and safety. They got to be involved with employee complaints. So if an employee comes to you and says, this machine isn't safe, Joint Health and Safety member is generally involved. They'll review injury and work hazard reports, monitor hazard reports and recommended action, participate in safety and health inquiries and investigations as appropriate, participate in resolving workplace refusals and work stoppages, make recommendations to management for incident prevention. That's a really important one. And lastly, they monitor the effectiveness of safety programs and procedures. So what is the Joint Health and Safety Committee? Joint Health and Safety Committee is typically it's comprised of at least one worker group and one supervisory group or management group. Generally, each person has to be trained, and depending on the size of the workplace, it could ramp up to multiple members of management, multiple members of the employer group. Taking a look at the responsibilities of the workplace supervisor. The supervisor ensures that workers abide by the act and regulations and wears the prescribed PPEs, equipment, or clothing. They have to advise workers of hazards in the workplace, the rules, and provide written instruction where required. The supervisor takes every precaution reasonable in circumstance for the protection of the worker. So again, that's sort of every precaution reasonable is coming up again. Occupational health and safety really views supervisors as a strong component of a health and safety management system. They view that as essentially the middle person between the company and the actual workers themselves. And so therefore, they really view supervisors as having a very important role in health and safety. And again, we already discussed the nuance that our industry has, where generally the supervisor is deemed at the agency themselves as well as the client. So what are the responsibilities of the agency? Provide required training regarding OSHA and Provincial Compensation Acts. We must ensure that protective devices, whoever it's provided by, such as work boots, eye protections, are maintained and used in the workplace. We have to ensure that workers abide by the act and the regulations and wear the prescribed PPE, equipment, or clothing. So we have to make sure they're operating safely. We have to ensure a copy of OSHA must be posted in the workplace. So as you look at the differences between the client and the agency, almost the exact sort of responsibilities. What are the rights of workers? There are three fundamental rights in every jurisdiction of Canada. Alberta has one note. It's slightly different, but overall, it's almost the same. We have the right to know, the right to participate, and the right to refuse unsafe work. Both the agency and the client have employer duties under the law to protect health and safety. And these apply to all employees. Doesn't matter whether they're full-time, temporary, they're contractors. They have the right to be informed of known or foreseeable hazards in the workplace. They have the right to information, instruction, training, and supervision. And they need to have that to ensure the health and safety of the workers are maintained. So looking at the first right, the right to know. You have a right to know about what hazards are present in the workplace. You need to be given the information, training, and supervision you need to protect yourself. This is a really important one for us. Now, we are supplying, depending on your workplace, but if you're doing sort of day labor or true temporary sort of assignments, You're going to be sending employees to different workplaces. And you have a responsibility under OSA to provide information to that employee about the hazards in that workplace. One of the easiest examples I have is the idea of food allergies. So if you're supplying workers to a food production facility, and in that food production facility, they work with peanuts or nuts, shellfish. You have responsibility. You should probably be telling every single new worker that is being supplied to that workplace of the presence of these things. Now, we're all fundamentally aware of some of these food allergies and how serious they can be for some people. For some people, they could be lethal if they're exposed to peanuts or shellfish. They don't have to necessarily eat them, just depending on their particular allergy, just being exposed to it could be a problem. So in our case, if we're looking at this from our perspective, the right to know means we have to ensure we know what the hazards of our clients are and that we are informing our employees of those hazards. The second part of this is the right to participate. What this means is employees have the right to ensure that the workplace is healthy, safe, make sure that they are going to be injury-free as best they can be, and they're going to be given the ability to ensure that through the joint health and safety. So the right to participate is being able to say to your employer, I'd like to be part of the joint health and safety committee. So you're actually a functioning member in ensuring the safety of that environment. And again, this right is shared across all jurisdictions, all provinces, all territories, and federally. We have this basic 3 rights. Lastly, the right to refuse work. So this means you have a right to refuse work that you believe to be dangerous to yourself or your coworkers. It doesn't necessarily even have to be you making a work refusal. When you exercise your right to refuse work, you must follow the proper procedure. Conversely to that, if you're the employer, you must also follow the right procedure. You have to deal with a work refusal in a very specific manner. And we'll go through that in a few slides from here. But what these do is encompass the 3 basic rights. This is one of the things, if you don't have it in your onboarding for the temporary associates, you probably want to include that information. Most jurisdictions will, again, if you have an inspector come into your workplace, they're going to want to know that the basic information, basic safety information, is being trained on for even temporary workers in the workplace. We have another multiple choice. So when should you do a site-specific hazard safety assessment at a new customer site? Should you do it prior to the assignment starting? Should you do it within the first 48 hours? Prior to the assignment starting, or if new hazards have been introduced to a worksite prior to the assignment starting, or repeated when conditions at the worksite changes? C, or option F, A, C, and D. So pretty universally, all the answers it looks like is F. So we should be doing these site inspections prior to the assignment starting. So you're going to want to, before you send anyone into the workplace, you want to make sure it's safe. You're going to want to make sure you want to partner with that business. You're going to want to make sure anytime there are new hazards introduced. So it could be a new machine being put in. It could be you're starting to supply workers to a different area of the facility. So maybe you were just in shipping and now you're in receiving, and it's a completely different area of the plant. You're going to want to go take a look at that and make sure it is safe. And the repeated when conditions at the work site changes, again, it could be they're moving sites, it could be moving shifts, it could be different people, different areas. You want to make sure that wherever you're supplying workers to, you have an understanding of what the safety situation looks like. And within our company, I explain it. This is the easiest way I've come across to explain it. So your representation is of your company. You're going in and you're looking at a client. And if you're looking at any sort of area, just ask yourself a simple question. Would you send a loved person, someone you love, someone you care for, into that work environment. Whether it's a child, a spouse, a mother, father, favorite aunt or uncle, would you send them to work in that facility? And if your answer is no, you're going to want to ask some questions. You're going to want to delve a little bit deeper into the client and figure out, okay, maybe what I'm seeing isn't great. Maybe there's something else. But I always base it on that. Would I send someone I know into this work assignment? Um, if the answer is yes, probably, it's probably a good place to work at. If it's no, you're going to want to consider um, your future business arrangement with this customer. Going to switch gears a little bit. We're going to start looking at WMIS, called a global harmonized system now. And we're going to be looking at it from a number of perspectives. So there's some things you're going to need to know for WMIS. And WMIS in our industry is typically, at least from what I've seen, our industry really embraces WMIS well. And there's two components. There's the sort of the written training that you got to read. So that'd be the history and some of the stuff we're going to go through today. And then there's the more practical part of it is when you're dealing with a specific chemical. What are the procedures for dealing with that chemical? How do you do so safely? In general, our industry does a pretty good job at the education piece. It's the more practical part that we need to ensure our customer is doing. We can't be experts in every single customer, every single chemical, and every single chemical that our various customers have. It would be an impossibility to keep that sort of information bank and to train our people on exclusively. And again, this is where commercial contracts come in. You say, okay, we're doing the education piece. Mr. or Mrs. Customer, you have to do the actual practicum of the substances in your workplace. What this is known as right to know legislation. It applies to hazardous products. There are several pieces of legislation collectively called WMIS, and they're all kind of grouped together. It's a comprehensive plan for providing information on hazardous materials intended for use in workplaces. WMIS, it applies in all Canadian workplaces, which are covered by occupational health and safety legislation, and where WMIS controlled products are used. Compliance is critical, and therefore knowledge is essential for you, the worker, and the customer. And we'll be going through each one of these areas: history, classifications, hazard identification. We'll have a slide on each one of these. And lastly, we'll follow it up with the worker rights, which is important. So we won't go too deep into this, the history of WMIS. Ultimately, WMIS isn't all that old within Canada. In 1979, and some rumbling started dealing with a lot of chemicals. There's new chemicals in the workplace. And the various parties, labor, management, and government recognized that there were injuries happening and we needed some sort of process for dealing with it. And as often the case with health and safety, an event kind of spurs that into action. You can talk about safety, but until something happens, a lot of times, it gets put on the back burner or you study it and evaluate it. What happened in November 1979, there was a massive train derailment in Mississauga. There was an explosion. There was a release of toxic gas that caused the evacuation of over 200,000 people. Now, with that major event, the government kickstarted a lot of this action into place. There was the introduction of transportation of dangerous goods. There was a report was published by what they call the tripartite. Again, that's labor, customers, or companies rather, and the government. And they published what was called a WMIS report of the Project Steering Committee. And by 1988, there was an execution of WMIS on a national basis. WMIS, which was effectively known as now as WMIS 1998, is the old style WMIS. In 2015, there was a change in how WMIS was perceived, and we'll kind of go through what that looks like. But just understand it's now called, if you see it in a textbook, it'll be called WMIS 2015. It's been in place for 10 years now. It is for all intent and purpose just called WMIS now. It's well enough established. We are all required to be under the new rules of WMIS, which again we'll go through. But it is the new way of doing it. And I'll explain kind of why we did this. So the intent of the global harmonized system is to level the international playing field. So what it is we recognize that we are a global economy. We are trading with countries, despite all the tariff talk with our neighbor down south, we are still actively trading with all sorts of countries. And if we thought we had a mess in terms of occupational health and safety by having different legislation for each province, when you start dealing with different countries, that expands exponentially. What happened so by December 1st, 2018, all parties must be compliant in Canada with WHMIS. And this little infographic on the side is a classic example of why it was necessary. What it does is combine the interests of all countries and developing a safety system, recognizing again that we're all trading, we're buying product from all sorts of different countries. We're sending product to all different kinds of countries. And we had a big mess prior to this global harmonized system where we combined everything together. And this is a perfect example. This is one product pre 2015. In Canada, US, Japan, Korea, it was listed as toxic. It was listed as harmful in the EU, Australia, Malaysia, and Thailand, moderately toxic in China, hazardous in New Zealand. And in India, this exact same product, no difference, it was listed as non-toxic. Again, all sorts of differences between countries in terms of health and safety. And what the net effect of this was we all kind of came together as a global trading partners and said, okay, we need to ensure the safety of our workers. And in doing so, we developed what's now known as the Global Harmonized System. In Canada, we call it WHMIS. I'm not going to go through the areas that changed so much because, again, this is 10 years old now. You are fully entrenched. Some of you may only know this current stage of WHMIS. One of the biggest parts of WHMIS is the presence of what they call pictograms. And we're looking at the Canadian pictograms under recognized WHMIS. Some countries may have more, but there are certain similarities with pictograms that we have. And the idea are these are graphical images. So you're not going to see text. You will see text, but just by presence of the graphical image, you're able to understand that this is a hazardous product and understand what type of hazard may be present. With a quick glance, for example, you can see that the product is flammable or that it might be a health hazard. Now, most pictograms have a distinctive red square set on one of its points. So the little diamond shape, and inside you're going to have the actual symbol itself that represents the potential hazard. Together, the symbol and border are referred to as a pictogram. And then pictograms are assigned to specific hazard classes or categories, which I'll explain what they are in a slide. As you're looking through these, they're fairly self-explanatory. So even with rudimentary training, even if, let's say, English is not your first language, or you're a newer young worker, you can almost understand exactly what it is. You know, the exploding bomb looks like something exploding. Flame looks like a flame. Corrosion looks like, it's corroding a hand and piece of metal or whatever it may be. Very easily understood. Again, it doesn't matter your education, doesn't matter your level of language. You can probably understand that what the hazard is, and more so that you are going to need more assistance in dealing with this particular product. There are two groups listed under WHMIS. Physical hazard groups, what that is based on the physical or chemical properties of the product. So it's a flammable, reactive, corrosive to metals. The second part of the hazard groups are what the health hazards are. So what is the product going to do to the human? What sort of health effect is it going to have? Are you going to have eye irritation, respiratory issues, allergy, breathing difficulties? Is it going to give you cancer if you keep using it? And within those, you have hazard classes. So your physical hazards and your health hazards. For example, physical hazards could be flammable gases, flammable aerosols, oxidizing gases. The list could be, it's much bigger than this, but it's just a representation of what it could be. Hazard classes are a way of grouping together products that have similar properties. So most of the hazard classes are common to the GHS and will be used worldwide by all countries that have adopted GHS. Some health classes are specific to WHMIS 2015. Second class health hazards, again, that looks at, okay, what sort of effect is that going to have on the human? going to be acutely toxic. It's going to cause skin corrosion. Um, Health hazards not otherwise classified. All these things are the actual effect on the human being in themselves. Another question, labeling. True or false? Labeling materials is a way health hazard information is made available to users, and although it is not required by law, it is recommended that all hazard materials be labeled. Go ahead and record true or false. A lot of quick answers on this one. So hopefully a lot of people picked up on it's not required by law. When this is a law, it is a piece of legislation within Canada. If you're operating a business in Canada, you have to operate under it. So the answer is false. Labels are required by WHMIS law, and we're going to show you what labels may look like. In Canada, WHMIS is one of the ways health hazard information is made available to anyone using the material. Labels are important because they are the first alert that there may be hazards associated with using the product covered by WHMIS legislation. Labels also tell us what precautions to take when using the product. They also inform that there is an SDS sheet, safety data sheet, available, which contains more detailed information on the product. So another question, what's the purpose of labeling? Labels tell the precautions to take when using. Labels are a requirement under government regulations. You can relabel at any time when there's a change in substance. It tells you that there is additional information on the SDS. All of the above, or number F, A, B, and D only. Please go ahead and record your answer. Yeah, so number F is the correct answer. And we'll kind of get into, we're going to be discussing labels quite a bit right now, but yeah, great answer, everyone. Number F, labels tell what precautions to take when using, required under government regulations, and it tells you that there's additional information on the SDS. So what are labels? Well, there are two different kinds of labels that are used most often. There's a supplier label and there's a workplace label. We're going to be taking a look at each one of them. The first one, supplier. One of the things you're going to want to understand is that these are the information of the product itself. And a couple things has to be in both official languages. So here in Canada, our official languages are English and French. You're absolutely able to have more information on the label. So if you have a workplace that is predominantly, has a predominant language in that workplace, absolutely fine to do that. Perfectly good. But just understand you have to have English and French. There has to be a product identifier. So the brand name, the chemical name, the common name, generic name. There has to be something that identifies the chemical itself. And generally, you want to know what the generic name is or what this thing is called. You have to have the initial supplier identifier. So the name, address, telephone number of either the Canada manufacturer or the Canadian importer. So you need to know who has manufactured this product if it's made in Canada, or if it's imported from a different country, who is the importer of that product, of that chemical. And the idea is if there is a major disaster, such as the Mississauga train derailment of 79, you have to understand who to contact if there is a major incident. If you need more information in dealing with the product, that's over and above what's on the SDS. Labels need to have a pictogram, so that those are the little symbols that we looked at in the previous slide. It'll need to have a signal word, danger or warning. Danger is used when there's high-risk hazards, while warning is used for less severe hazards. And that kind of makes sense. Hazard statements, which I'll show you, but what they are standardized phrases which describe the nature of the hazard posed by the hazardous product. Precautionary statement is a standardized phrase that describes measures to be taken to minimize or prevent adverse effects resulting from exposure to hazards. So how do you deal with it? How do you save yourself from having actual issue with it? And then supplemental label information. It's more information based on the classification of the product. Could be precautionary actions, hazards not yet included in the GHS, physical state, or route of exposure. This is what a supplier label could look like. So a supplier label it doesn't necessarily have to look like this. There's no sort of aesthetics required of it. It's the information on the label itself that is important. So at the top, we have the product identifier. In this case, we have product K1. And remember, it has to be in English and French. We have the pictograms. We have the signal words. So in this case, it's danger. We have our hazard statements. So it's fatal if swallowed, causes skin irritation. Precautionary statements. So how do you actually deal with it? What are some precautions to take to minimize any sort of effect? And lastly, we have the supplier information. So this company XYZ, we have the information on how to contact them, who they are, what their phone number is. Again, in case of a more serious incident itself. So the suppliers themselves or the importers are responsible for labeling women's control products that provide to customers. Customers, sometimes the workers, are all responsible for labeling or relabeling products in the workplace as per the occupational health and safety legislation. So it is, again, it's the supplier or the importer of the product that has to have this information available. Secondary to this is what's called a workplace label. Workplace label does not have any sort of requirements. It is more an identifier of what the product is. And a workplace label is required where there's a hazardous product is produced in the workplace and used in that workplace. So if you're a manufacturer of Windex and the specific brand of Windex or specific formula Windex is under WHMIS, you will have to label it if you're using it in the factory. Second hazardous product is decanted. So if you're taking it from a larger sort of drum and putting it into a more manageable size. So the supplier label is going to be on the drum. As you decant it or put it into the other vessel, you're going to have some way of identifying the smaller vessel of what's in that product. And lastly, you can use it if a supplier label becomes lost or illegible. So if the original supplier label, because of whatever the environment, you can no longer understand what it is, you can provide a workplace label at that point as an interim measure. There are two situations where a workplace label is not necessary. It's when a hazardous product is poured into a container and it's going to be used immediately, or it is under the control of the person who decanted it. So what that means, for example, let's say you have a person who poured the product into another container. They're the only person who's going to be using it. So they're going to consume that product within, a short period of time. They're going to be in care and control of that product the whole time. They do not necessarily have to put a label on it. Doesn't mean you don't want to in some cases. You may want to have health and safety processes that are over and above, but you don't necessarily have it in this case. As we're looking at this is just an example of what a workplace label may look like. Again, there's no sort of aesthetics for it that have to be maintained, but you do want to have the product named. You want to know that like what the product is, and that product, the name of it must match what's on the SDS product name. So you're going to need to, it's going to be the exact same thing, whatever the generic name or the supplier name or whatever it may be, you have to have that information. So you can say, look, this is chemical ABC. And then you can go back to, if there's a problem, you can go to your SDS sheets and find chemical ABC. You need to have the safe handling precautions. Again, wear a face mask or keep a well-ventilated area. And then you have to have a reference to the SDS if available. So safety data sheets available. I understand there's a product where there is more information available on site as is health and safety precaution. With the hazard statement, each hazard class category has an assigned hazard statement. Hazard statements are brief, standardized sentences that tell you about the exact hazard of the product. Statements are short, but they describe the most significant hazards of the product. Some examples: extremely flammable gas, contains gas under pressure, may explode if heated. Fatal if inhaled, causes eye irritation. The wording of the hazard statement helps to describe the degree of the hazard. So may cause cancer is more hazardous than suspected of causing cancer. Another multiple choice. What does SDS stand for? Under WHMIS 2015. Safety data sheets, safety directive sheets, safety decree sheets, or safely dictate sheets? Flurry of A's have come in. So yeah, the answer is A. I've said it probably 100 times in the last 3 slides. Safety data sheets. So what is a safety data sheet? It's a document that contains information on the potential hazards, health, fire, reactivity, environmental, and how to work safely with the chemical. In Canada, every material that is controlled by WHMIS must have an accompanying SDS sheet that is specific to each individual product or material. And it's important to make the distinction that SDS sheets are prepared by the supplier or manufacturer of the material, and that's not the workplace. Again, I showed you what the workplace label may look like. It is intended to tell what the hazards of the product are, how to use the product safely, what to expect if the recommendations are not followed, and what to do it most importantly, if accidents do occur, what do we do? SDS are an essential starting point for the development of complete health and safety programs. So taking a look at this, we kind of discussed that there's two essential parts to WHMIS. Again, I think our industry does this incredibly well. You have the education program, and then you have the more practicum program. So the education program must include instruction and labels, SDS, hazard information, procedures, use, handling, storage, disposal, presence of hazardous material, and emergency procedures. All of those comprise the full education program. In general, though, the first three lines are the education piece. You can discuss the labels, the SDS, the hazard information. All those are universal bits of information. As you're talking about very specific chemicals, though, you're going to want to rely on the expertise of the customer to train on that specific substance or fluid or whatever it may be. What the law requires us to do as employers is educate a worker exposed or likely to be exposed to a controlled product. An exposed worker is any worker who stores, handles, uses, or disposes of a controlled product, or, and this is important, who supervises another worker performing these activities. So not every worker is necessarily required to perform MS. I think it's a fairly safe process developed in our industry, though, at least from what I've seen and from what I've heard from other temporary employment agencies, we typically tend to train all our workers on WHMIS. If you have any questions about that in particular, I mean, you're welcome to contact ACSESS. They'll more than have some information to help you out with. But in general, that is sort of the thing that we've adopted because we never really know at the time of inboarding. Most of the time, we don't know what customers this person may be assigned to. So it's really important to make sure that we are doing our due diligence and training workers on WHMIS programs. There is a retraining responsibility. It is typically after 1 year, you have to retrain the worker. And that's just to make sure that they don't forget that information, make sure that their retraining is keeping at the top of their mind. What are employee responsibilities? We've discussed what the employee responsibilities are pretty in-depthly. So the labels and the training programs and so forth. Employees have a responsibility, have a number of responsibilities within WHMIS themselves. They have to, first off, attend any sort of education training programs. And second to that, they have to actually follow what they've learned. So they can't just use products and disobey what the safety rules and regulations are. Or as a company, as an employer, you should be disciplining these people. And this applies to customer sites as well. Just very little differences between employers with that regard. As well, workers should work in compliance to the Act and regulations. They do have to wear the prescribed PPE equipment and clothing. So if the customer site requires, let's say, face protection or eye protection rather, the employee is required to wear that. If it is mandated by that particular work site, the employee has to wear that. And lastly, they have a responsibility to report any hazards, machine defects, and any contraventions of the Act to the supervisor. So as so often with pieces of legislation, they kind of dovetail into each other. So there are, this particular one talks about WHMIS regulations, as well as talking about occupational health and safety legislation. So especially in health and safety, they do dovetail into each other. There are duality of responsibilities. So we are going to switch gears. We're on unsuspecting hazards, but we are going to take a break right now. So it's 2:03 on my clock. We're going to come back at 2:08. So please go take a break, go stretch, to the washroom. We'll be back here at 2:08, okay? Looking at hazards. We're gonna start looking at hazards in the workplace. And one of the things with hazards, they can be found in essentially every workplace. It doesn't matter if you're working in an office or you're working on a construction site, hazards are present and common in basically every aspect of our lives. They come from a wide range of sources, and we're going to take a look at some of the more common workplace hazards and how we actually deal with them from a health and safety perspective. We're going to be looking at a particular case study that starts this off. So this is from Ontario, 2015. It involved three workers who were working on an asbestos abatement project at a single-family home. The abatement area is enclosed. In that area, certain asbestos-containing materials had been removed, and there was asbestos dust hazard present. A Ministry of Labor inspector attended and conducted an inspection. The inspector found one of the workers exiting the workplace wearing street clothing. Two other workers were found inside the enclosed area not wearing protective clothing. One was performing cleanup, and the other was securing bags filled with asbestos-containing material. Ministry of Labor investigated and released a statement. There is potential for harm where workers or others are exposed to even small amounts of asbestos. Ultimately, there was a court proceeding, and the company pleaded guilty to failing to ensure that only persons wearing protective clothing and equipment entering the work area where there is an asbestos dust hazard. The company was fined $25,000. Ministry of Labor generally does not put out a press release for individuals for less than $50,000, but they were making a special case in this particular case. Interesting enough, the supervisor was fined $4,000 after pleading guilty to failing to ensure workers use protective clothing and equipment. So there are a number of things involved with this as a case study. Asbestos is one of those materials which we'll get into, which is listed as a designated substance. Essentially, we recognize in society that this material is dangerous enough to want to pay special attention to it. And there are very specific rules and regulations in every jurisdiction for dealing with asbestos. Some of the particularly large hazards that were in place here is there's no protective clothing provided. So the idea is if you are dealing with asbestos, you have to follow the regulation for asbestos removal. One of those items is must wear protective clothing. The idea is you don't want to be wearing street clothing as you're dealing with the asbestos. Reason being is it's a very fine, very fine. You can't see it. You don't know you're breathing it. What happens though is it gets attached to your clothing. And so even though you think you're being safe, it is attached to your clothing and it can be therefore transported outside of the work area. The other factor was it was clear that there was basically no rules or regulations being followed. So it's pretty clear that this company did not know or chose not to follow the rules of asbestos abatement. And a lot of times that includes protecting the area. So you do have to secure it. You have to make sure that any sort of asbestos material is contained. There are very specific things on how to deal with it. You have to make sure that the air is being actively processed. And ultimately, it's clear that this company, by fact of the judgment against it, was not following the health and safety protocols properly in this case. Asbestos is one of those interesting things. We stopped about in the mid-70s in Canada selling it. It's still present though. It still is in our environment. And we'll kind of discuss that a little bit. Asbestos is interesting because there's no safe working limits with it. The government's not has never said you're able to be exposed to this much asbestos because they simply don't know. It's also asbestos tends to affect people differently. Some people can work with, back in the 60s, 70s, there were people working with asbestos every single day. And then there were people exposed to asbestos, even minutely, that had long-standing health effects from it. So this is more just to highlight, again, from the perspective of a temporary employment agency, would you supply to this? Well, no, without some very serious sort of assessment of that customer. In this case, if this was a temporary employment agency supplying to it, I would say that the temporary employment agency did not follow any sort of site inspection or risk analysis sort of process. And then they've basically failed their health and safety due diligence. What are so we're going to look at hidden dangers. What are designated substances? So designated substances could be a number of things. Biological agent, could be a chemical agent, physical agent, or any combination of the above. So a designated substance is any to which the exposure of a worker is prohibited, regulated, restricted, limited, or controlled. So with Ontario, the word designated substances is a very Ontario-specific aspect of regulation. So if you're in a different province, you may have something very similar depending on what province you're in. But just understand designated substance is a very specific Ontario term. And in saying that, right now there are currently 11 chemical agents that have been classified as designated substances. So we'll go through the 11. Right now it is listed as Regulation 49 or 490-09 designated substances. And what this does is identify the requirements if these substances, so any of these 11, are present in the workplace. So the employer must review the work methods and assess the likelihood of worker exposure. When there is likelihood of a worker exposure, a control program must be instituted that includes engineering controls, work practices, hygiene practices, record keeping, and medical surveillance if applicable. So there are very specific things you have to do if you are dealing with these substances, or you're going to be exposed in the workplace to other people dealing with these. So you're going to want your joint health and safety must be consulted. So for our industry, we want to make sure we ask the question of any of our clients, are you working with designated substances? And are the workers we're supplying going to be exposed to that? If that is the case, then you have some very specific information, processes, procedures you need to ensure are present to safely supply that sort of work in the workplace. So where there is a designated substance, the supervisor must be involved in what's called an assessment of the use. The assessment is to determine if a health hazard exists for workers and whether or not a control program is required. It includes the following: information on use, handling, storage, and disposal, actual and potential exposure of workers to that substance, and methods and procedures required to control that exposure. So they have to assess whether or not, or how likely it is that this substance is going to be effective to a person's health. Taking a look at it, I always have a problem with this one. Acrylonitrile is used primarily as the starting monomer in the manufacturing of synthetic polymers such as acrylic fabrics found in carpets. Arsenic. Number 2, arsenic is a strong poison, so it's in wood preservatives, insecticides, herbicides. It's also used in making alloys of copper and lead. Asbestos we discussed, but asbestos is it was essentially a wonder compound in the 70s, in the 60s and 50s. It is mined, so it's from the earth, and it essentially didn't burn. So what happened when new furniture was starting to be used by some of these new plastics and polymers, as soon as a flame touched it, they would ignite. So they had real problems. So asbestos came around, whomever discovered it, and it was essentially used in everything pre-70s. So insulation, wallboard, asphalt, adhesives, caulking, ceiling and floor tiles, gaskets, drywall compound, plaster, and roofing shingles. So if you were asked to supply labor to a company that is doing asbestos abatement or construction or anything of that nature of heritage buildings or buildings older than 1970, very good chance your workers may be exposed to asbestos. So it doesn't necessarily mean you can't do business with it. You just need to understand there have to be very specific processes put in place for dealing with that. And again, making sure you're involved with a client that has the processes involved so you're dealing with a good safety partner. Benzene, number 4, benzene makes other chemicals, which are then used to make plastic resin, nylon rubber, lubricants, detergents, drugs, and pesticides. Benzene is also a natural component of crude oil and gasoline. Ethylene oxide is from the manufacture of ethylene glycol, surfactants, fumigants, fungicides, and petroleum demulsifiers. Coca oven emissions are the airborne constituents of the byproduct created by destructive distillation of coal and petroleum. So anytime there's burning of coal and petroleum, you're going to have coke oven emissions. The emissions can occur from the production of steel, from petroleum products, and from the lining of high temperature furnaces. Isocyanates, they're typically found in spray foam insulation, sealants, finishes, paints, and auto body materials. Lead, again, very similar to the sort of place where asbestos maybe used to be used in paint, old mortar, old water pipes, lead sheathing, and contaminated soil. So again, if you're doing work on heritage sites, good chance you're going to be exposed to lead. Mercury, typically present in fluorescent bulbs, switches, pressure gauges, generally the older style ones. We recognize the inherent danger of mercury, so it's not used as often in those products. Silica, second to last one, a lot more common. So it's in bricks and blocks, granite, abrasives, concrete, sandstone, cement, and mortar. Silica is not really a problem until it's airborne, very similar to asbestos. So until you're actually disturbing it, if you're cutting into it, what happens is it becomes airborne, becomes fine particles. And one of the things we do very, very often, 50, 60 times a minute sometimes, depending on what you're doing, is you're breathing. And inhalation is the number one route inside the body. And so when you're actually making these products airborne, very easy to get into the body. Lastly, vinyl chloride used to manufacture PVC, which is basically used for everything, furniture, upholstery, pretty much every plastic products may have PVC in it. So ultimately, what you're going to need to do is ensure that part of your risk analysis, your safety inspection of clients, has a component of asking about these designated substances. Are you working with them? Are you dealing with them? Are our workers going to be exposed to them? We're going to take a look at some other typical workplace hazards. Number 1, confined spaces. Confined spaces are one of those ones that typically most jurisdictions have regulation on how to deal with them. And the reason being they are intimately capable of harming someone. So depending on the nature of it, depending on what's in there, it is very easy for someone to be lethally harmed. And so what is a confined space? Some examples could include silos, vats, hoppers, tanks, sewers, pipes, access shafts, truck or rail cars, manholes, manure pits, storage bins. Ditches and trenches may also be confined space. And typically what confined space is a place not generally used for human occupancy. So if you think about like a milk truck, a milk truck has a very limited sort of means of getting in or out. It has confined airspace, so the air is not going to be immediately recycled. You are going to have issues if you have to extricate someone. So if someone does pass out because the gases, if you've ever seen a manhole cover or any of the utilities working on manhole covers, you're going to see a few things. You're going to see like a means they have this frame and the worker's attached to it. So if the worker does pass out because the air is poor, the other workers have an ability to extricate the person, get them out of that area. A lot of times you have to have very specialized air monitoring. Depending on the jurisdiction, you may have to have what's called a spotter, or different places call them something else, but someone on the outside that's not involved with the actual maintenance item. They're essentially an overwatcher of the area. Confined spaces are something you are going to want to identify if your customer requires them. They make sure that the customer, again, is a good safety partner and that they know what they're doing and that they're doing the proper things and that they are ensuring any sort of workers are aware of the hazards of the confined space. A little bit more common, moving on, indoor air quality. Um, all of us, or most of us, probably have lived through COVID. Remember COVID? It wasn't that long ago. We were intimately aware of indoor air quality. This has been a hazard forever, and the reason being, again, because inhalation, so breathing, is the most common means of route inside the body, and it's typically associated poor indoor air quality with poor heating and ventilation systems, so HVAC systems. You could have issues with contamination from construction materials. So we were talking about asbestos and silica and so forth. And indoor air qualities may arise from any of the following causes. So it could be the environment itself, humidity, lighting, excess noise, contaminants such as chemicals, dust, molds, fungi, bacteria, gas, vapors, odors, insufficient outdoor air intake. Indoor air quality typically becomes more of a problem in winter when especially in Canada, generally we shutter the workplaces. There's no windows open, there's no doors open. Um, so indoor air quality is one of those hazards we do have to be cognizant of. Lasers, laser beams, the hazards are typically for eye. So you don't point a laser beam in your eye. But there could also be skin burns. Could also be in terms of some medical procedures where they are burning something. The fumes emitted from the materials can get into the body and cause issue. So such as surgical procedures or it's used for cutting. Moving on, scents. This is probably more common than it used to be, but scents are something that is a problem. A lot of workplaces you may have been exposed or seen or just public areas have scent-free areas. And the reason is some people have an acuity to it. They have a very harsh health reaction if particular scents are, if they're exposed to particular scents. So what we mean is usually smells or odors from cosmetics or other products, such as air fresheners, cleaners, perfume. And scents can cause adverse health effects, including headaches, dizziness, and nausea. So some people, most of us are not going to have strong health effects to it. Some people are going to have very pronounced health effects to it. So it is something that you do have to be aware of and understand it may be a hazard in specific work environments. Second part of number 4 is temperature. So in very hot environments, the most serious concern is heat stroke. In a cold environment, hyperthermia and frostbite. Well, there's no maximum temperature specified. Legislation does include a range of acceptable temperatures for various circumstances. What does that mean? So that means there's no high level. So we don't have to do anything specific if the temperature is at 34. So the government does not specify that. You may want to, as a general duty or as a reasonable precaution, ensure that you have processes for heat stress, especially as global warming becomes more prevalent. So people working outside are exposed to more extreme high heat levels. But typically, occupational health and safety legislation does not apply to that. It does, however, apply to cold temperatures. And so in our industry, if you're working outside, if you're working in a cooler, if you're, let's say, a forklift driver coming in and out of like a freezer area, you are going to want to make sure you have some sort of process or procedure to deal with the health and safety hazard of the cold weather. Secondly, to that, temperature is the number one complaint in offices. And again, it is listed as the number one complaint. Some people want it hotter, some people want it colder. Doesn't necessarily mean that's more of a comfort thing at that level. What we're talking about is more extremes. So, minus 32 degrees Celsius or plus 32 degrees Celsius, you're gonna have some very serious health effects from that. We're not talking about 21 degrees Celsius to 23 degrees Celsius. That's not really contained in the health and safety legislation. Ventilation kind of coincides with indoor air quality, but ventilation is the actual mechanical system in a building that brings in fresh air, removes contaminated air. In workplaces, ventilation is used to control exposure to airborne contaminants by removing fumes, dust, and vapors. So a lot of times if you're dealing with that or dust or like wood shavings, wood dust, the mechanisms of actually like cleaning the air, like taking that from an enclosed workplace and putting outside and making sure that the workers are safe. We'll get into violence a little bit more, but violence is something that we cover in depthly in the next couple slides. Weather. So weather is obviously, we're in Canada. We have some extreme weather events. The weather events seem to be getting more extreme. Um, but even looking aside from that, things like lightning, things like wind, if you're working at heights, all those things can be very impactful. And you want to make sure that you are understanding the hazards and if they are present, controlling those hazards. Violence, like I said, we'll talk about violence in a little bit. And lastly, working alone. Working alone is something that is in some provinces actually identified specifically in the occupational health and safety rules legislation. In others, it more falls under the general duty clause. But working alone is definitely something that can be problematic, and you are going to want to do specific assessments, and it's probably going to be dovetailed with your violence and harassment policy, specifically within our industry. And the classic example that I always use is the idea of a gas station attendant. If you remember from like 20 years ago, gas stations are typically open late at night, and all the common hazards associated with working alone are present in a gas station. You have working alone, you have working with money, you have working with high value products in the case of the confectionery items and the beer and tobacco. And lastly, you have like dealing with the public. So if you ever look at a gas station now, a lot of times late at night, they may have multiple people working. They may have a time safe. They may have, high value products behind a locked door. And in some cases, you may not even be able to enter the store. You have to provide the transaction either outside the store or actually at the machine themselves. And those are some sort of controls that have been identified as being advantageous for people working alone. For our industry, you want to make sure that if staff are working alone, that the client themselves have some sort of process for dealing with that, for meeting that sort of challenge. So taking a look at, we'll talk about workplace harassment and violence. This is something that has become much more prevalent over the years. We recognize that harassment, violence, sexual harassment in the workplace is not acceptable. You don't have to just sit there and put up with it. It doesn't matter whether you are a full-time employee, a union employee, temporary employee, or a visitor to the workplace. We do not condone harassment and violence in the workplace anymore. So both the agency and the customers have to have a policy and program in place to support violence and harassment. Program needs to be maintained and made aware to workers through training and ongoing awareness. So the violence and harassment program, a lot of times they are combined. They aren't separated. There's no need for them to be separate pieces of policy, but often they are. And what they must do is include measures and procedures for controlling risks. You got to make sure that when there is something that happens, you are appropriately dealing with it through investigation, through training, retraining, or through disciplinary process. And also, as in physical work conditions, workers have a right to refuse work if they have a reason to believe they're in danger of workplace violence. So what is workplace harassment? Workplace harassment, this is an Ontario specific definition, but every other province has something very similar in terms of the actual definition of it. In Ontario specifically, it's engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably be known to be unwelcome or workplace sexual harassment. What is workplace harassment? It can involve unwelcome words, unwelcome actions that are known or should be known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers in a workplace. It can also be behavior that intimidates, isolates, or even discriminates against targeted individuals, including making remarks, jokes, or innuendos that demean, ridicule, intimidate, or offend, displaying or circulating offensive pictures or materials in print or electronic form, bullying, repeated offensive or intimidating phone calls or emails, or workplace sexual harassment. In the modern age right now, it includes any sort of virtual meetings. You're not allowed to harass people virtually. And most pieces of legislation now do identify it. Ontario is very specific in that. What isn't workplace harassment? Workplace harassment, it's a lot of things, but what it's not is a reasonable action taken by an employer or supervisor relating to the management and direction of workers or the workplace. So reasonable management actions can include the manager's normal work function, can include changes in work assignments, scheduling, job assessment, and evaluation, workplace inspections, implementation of health and safety measures, and disciplinary action. So telling a worker he has to make 60 widgets per hour and they're only making 15 is not workplace harassment. That is enforcing a general managerial function of the worker. Workplace sexual harassment didn't actually come first in Ontario. It was a secondary piece of legislation, and it was really born on a number of events that occurred, and it was important enough to identify it as a separate issue past just harassment. So what is workplace sexual harassment? It means engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome, or making a sexual solicitation or advance, where the person making the advance is in a position to confer, grant, or deny benefit or advancement of the worker. And that's more of about a power dynamic. So a supervisor demanding something from a subordinate, that would be deemed sexual harassment. And sexual harassment, it's similar, but not quite the same. It involves unwelcome words or actions associated with sex, sexual orientation, or gender that are known or should be known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers in a workplace. It can include asking questions, talking, or writing about sexual activities. It can include rough or vulgar humor or language related to sexuality, sexual orientation, or gender. Displaying or circulating pornography, sexual images, or offensive sexual jokes in print or electronic form. Leering or inappropriate staring, invading personal space. Unnecessary physical contact, including inappropriate touching, demanding hugs, dates, or sexual favors. Threatening to penalize or otherwise punish work if they refuse a sexual advance. One of the things you do have to understand is, again, this confluence of legislation and laws and rules and everything else. If you have a workplace sexual harassment claim in the workplace, if someone makes a complaint of it, it may actually be breaking the law itself. So the public law. So when the conduct or behavior includes inappropriate sexual touching, let's say, that could constitute a criminal offense. And you're going to want to involve the police at that point. So you're going to have your own responsibilities. You're going to have to investigate and so forth. If it is a criminal offense, though, get the police involved and do so immediately. Workplace violence is the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury. An attempt to exercise physical force against a worker in a workplace that could cause physical injury to the worker. So it doesn't necessarily mean you have to punch someone. It could be the attempt to punch someone can be deemed workplace violence. And lastly, a statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force against the worker. So saying you're going to fight the person in the parking lot after work, that can be construed as workplace violence. They don't necessarily have to fight the person. The mere threat of it can be deemed to be workplace violence. It also defines workplace violence as the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker. Now, what it can include, it could be verbally threatening to attack a worker. So what we just discussed. Leaving threatening notes or sending threatening emails to a workplace. Shaking a fist in a worker's face. Wielding a weapon at work. Hitting or trying to hit a worker. Throwing an object at a worker. Sexual violence against a worker. Kicking an object the worker is standing on, such as a ladder. Or trying to run down a worker using vehicle or equipment such as a forklift. So in these three realms, workplace violence, harassment, sexual harassment, they're spelled out in each one of our jurisdictions. There are very specific things we need to do. If you have a complaint of any of these things and you're unsure of what to do, you may want to seek legal action because, again, there are very specific things you need to do. For example, for harassment in Ontario, you have to investigate, and then you have to notify the complainant of the actions taken. So for example, if someone says they're being harassed, you must conduct an investigation. Has to be a valid investigation too. Like it has to stand up in court essentially. And you will have to notify the claimant of what you've done. So have you fired the person? Did you provide disciplinary measures? Did you retrain the person? And that has to occur. If they make a complaint later, the Ministry of Labor is going to take a look at it and say, okay, Mr. or Mrs. Employer, what have you done? This complaint was made. Did you investigate? Did you investigate properly? Did you take reasonable steps to protect the worker? Did you notify the claimant of um, the outcome? All those things have to occur. Workplace violence is another thing where it could be a criminal offense. You can investigate, sure, but if there is someone that was criminally violent, you may want to contact the police. Again, that may be something you want to seek legal attention for, or maybe you have some in-house counsel, maybe you have some HR. Those are the situations where if a complaint is made to you, you are going to want to notify your supervisor, your manager, what have you, because there are additional steps you're going to want to take. We didn't always treat violence and harassment the same. Again, these are fairly new. I think they're about 15 years old in Ontario, maybe a bit longer. But we recognize as a society that they are unacceptable. There's no place at all in the workplace for it. And again, it does not matter that they're a temporary worker. They should not be exposed to harassment or violence or sexual harassment in the workplace. So again, very serious for a reason, completely unacceptable. And again, if you are exposed to it, you must deal with it. Switching gears a little bit, hazardous sound levels. OELs are known as occupational exposure limits. And what it is the maximum duration of exposure permitted for various noise levels. So noise is measured in decibels. Each province has very specific rules for the loudness, so the high level decibels, which is known as a criterion. So what is the steady noise level permitted for a full 8-hour work shift? So for example, here in Ontario, it's 85 decibels. So a worker can be exposed to 84 decibels for 8 hours. And the current science right now says you're not going to have ongoing hearing loss from that level. If it exceeds that level, you have what's called the exchange rate, the amount by which the permitted sound level may increase if the exposure level is halved. So that means you may be able to be exposed to 86 decibels or 87 decibels for 1 hour. Again, it is the level of exposure to the decibels that is the important thing. It's a little more complex. It's obviously something that you can't just, it's too loud. This is a very scientific measure. Typically, occupational hygienists get involved with this sort of work in workplaces. How this applies to us, though, we want to make sure that if there are signs in the workplace, so if you're going to a client site and you see specific things, you understand that there are some precautions you must take. As the employer, you're required to protect workers. So you got to take all measures reasonably necessary to protect workers from hazardous sound levels. You need to implement controls, so measures of engineering controls and work practices to reduce the noise. So it could be changing the machine or adding a different process or exposure to that machine. Hearing protection is a control. It's typically the last level of control you want to implement, though. It is the one that you want to reduce the sound first instead of just adding a muffling effect to the noise. You have to have you have to have warning signs posted in the workplace. So for example, you have to have this workplace regularly has noise levels exceeding 85 decibels. That way, as a person entering that area, there's a hazard here. I must have some sort of hearing protection. Then you have to provide training to workers to make sure that they understand the hazard itself and the requirement to wear the hearing protection. So if your client says we need hearing protection, we've had an assessment done and this particular work area has 88 decibels of noise, all workers must wear hearing protection, which muffles the sound down to 85, which is an acceptable level. You need to ensure the workers are using the PPE required. First aid requirements. First aid requirements are a bit of a mess. across Canada. Each province has their own first aid requirements. There has been movement in place lately to coincide with some specific CSA requirements for that. Hopefully we can align it so that all provinces are the same. What I'm referring to today is the Ontario first aid requirements, but every province has their own very specific sort of things. And it'll differentiate between what the first aid training is actually called. So the content is the same, the name of it unfortunately is different depending on what province you're looking at. So here we have what's called Regulation 1101, it's WCIB regulation, and it defines what first aid requirements are in the workplace. So it talks about the first aid requirement services that have to be inspected. First aid stations must be easily accessible and near a worker who has a valid first aid certificate. So it can't be, at the very other end of a massive sort of warehouse. It has to be easily accessible, or you have to have multiple first aid stations. You have to have a notice board, first aid certificates, first aid, who are the trained people on duty. There must be detailed records of all incidents and first aid treatment given. There are specific training required. Again, this is very specific to Ontario, but all provinces have the same. For workplaces with 6 or more workers on a shift, standard first aid certificate is required. So some of the other provinces, instead of being called standard first aid, it's called basic first aid, or it's called whatever it's called in each jurisdiction. But understand that after a certain level of workers, you have to have a minimum level of training. First aid stations are under the care of the worker with a valid first aid certificate. So it has to be the typical thing is within a 2-minute walk. So it should be within a 2-minute walk of where the trained first aider is. CPR is a mandatory module as part of a first aid training program. And it does scale up. So if you're over 250 people, you essentially have to have a first aid room. Depending, the workplace is so large that you have to have a trained first aid or a first aid room on site. And it just scales up, depends on your province, but specifically, the most important thing is every workplace does have first aid requirements if you have any workers on site. Again, part of your risk analysis, your site inspections, you want to make sure your clients have these measures in place in the workplace. When we talk about OSHA and critical injury. So critical injury is defined as an injury that is serious in nature and does the following. Places a life in jeopardy, produces unconsciousness, results in substantial loss of blood, involves the fracture of a leg or arm, but not a finger or toe, involves the amputation of a leg or arm, hand or foot, but not a finger or toe, consists of major burns to a major portion of the body, causes a loss of sight in an eye. Critical injury is a definition in Ontario. Each other provinces do have similar sort of things, but just please, if you're out of province, these specifications are specific to Ontario. And when a critical injury occurs, so any one of these items, the employer must notify a Ministry of Labor inspector immediately by telephone. And they have to contact a member of the Joint Health and Safety Committee or the representative, depending on the size of the workforce. Together, they must conduct a thorough investigation. And then Section 51 of OSHA requires that all critical injuries be investigated, and a written report must be prepared and forwarded to the Ministry of Labor within 48 hours. So you have to notify the Ministry of Labor that a critical injury occurred. You're going to do that by phone generally. You have to conduct an investigation, and then you have to provide a written report to the Ministry of Labor within 48 hours. Understand that's different from what WSIB regulations are. This is to the Ministry of Labor. So we already talked about when you have to report that. You're gonna take a look at a scenario. And there are going to be a couple questions after the scenario about this. So a new client places an order for a general labor. It's the final assembly line that wraps and boxes cans of cat food. They'll then lift the newly packaged box and put it on a skid. Another worker will use a forklift to pick up the skid when it's full. The customer tells you that they run a very safe operation and have won an award. Training will be provided around their safety procedure. Safety boots are required, and gloves will be provided. After the second week, the employee placed at the assignment tells you that they will not return. The equipment that is used to put plastic wrap on the case of food is blocked, and they want you to push the product through with your hand using more force. They've also asked that in the absence of the forklift driver, you operate the forklift and move the skids to a designated area. You refused, but the supervisor said, it's okay, everyone does it. Lastly, you burned yourself while packaging and your supervisor told you to be more careful. You do not feel safe and the supervisor intimidates you. So quick question. You and the customer can discipline your employee for refusing to work. True or false? So it looks like all the answers are false. Very good. You cannot discipline your employee for refusing to work. If you remember back to the beginning of this module, we discussed about the three basic rights. The right to refuse work is a basic right of a worker in Canada. So you're prohibited from penalizing, dismissing, disciplining, suspending, or threatening to do any of these things to a worker who has refused to work based on the safety. Essentially, they're following their basic rights as we discussed earlier. So what is the right to refuse work? Discussed a little bit before, but an employee can refuse work at any time for the following reasons. The physical condition of the workplace or workstation is likely to endanger your employee. Any machine, equipment, or tool that the worker is using or the physical condition of the workplace is likely to endanger your employee or another worker. And again, that's important. Someone can refuse to work on behalf of someone else, or workplace violence is present and likely to endanger. So how do you support your workers in this? Number one, training. You got to make sure that workers understand they don't have to do unsafe work. They have that right. They will not be penalized. And if there are repercussions to that. Ministry of Labor can force a client to re-employ an employee. There are mechanisms that the government has to penalize the employer for it. And you really want to do this for new and young workers. They may not understand this sort of right. They may not be willing to express to a supervisor of the new job, let's say, that they feel unsafe. Another question. Will the employee will not be paid while refusing to work? So true or false? The employee will not be paid while refusing to work. Is that true or false? So we got pretty universally, we got false. Absolutely. Again, the employee is exercising their basic right. So an employee will be paid during the first, second stage of a work refusal. And we'll kind of go through what the stages of work refusal look like. So again, this is a basic right. Work refusals are spelled out in OSHA, and there are two stages. Stage 1 and 2 in this presentation are kind of combined. Other mechanisms might just say there's two stages, but in this case, if a person makes a work refusal, the worker must stop working immediately. They do have to inform their supervisor. The supervisor does have to investigate. They will involve the joint health and safety rep or representative. The worker must remain close to the site while the investigation is being conducted. They will be paid, as we discussed in the last call. You can't just send them home because they're exercising their right. And upon resolution, the worker must report the incident to necessary supervisors. So the employee must be the employee who is refusing work must be in a safe place near the workstation until the investigation is complete. This is called the first, second stage of the work refusal. If the situation is resolved at this point, the worker can return to work. So if it is, let's say, the worker is using a ladder and one of the rungs of the ladder is broken, the worker refuses to do the work because they feel they're going to hurt themselves. And they inform the supervisor. Supervisor goes and replaces the ladder, puts the other one and brings it to maintenance to fix or whatever they do, take it out of service. At that point, the issue is resolved. the employee is content that it's been resolved, and the employee can return to work. Stage two, again, stage one and two are kind of combined in some of these cases. Essentially, what this means is you're moving to the next stage. So stage three is where the employee has made a complaint, such as the ladder. Supervisor takes a look at that ladder and says, no, it's fine, keep using it. What you then have is a situation that is unresolved. You don't want to get to this point. You want to, as an employer, solve the situation at stage one. You want to make sure that you are able to resolve that situation. Sometimes what happens is that one employee can refuse the work, but another employee can absolutely do that work. So if you're talking about something, let's say lifting flour sacks that are 80 pounds, too heavy, granted, but if someone weighs 100 pounds, they're going to have a lot more difficulty than someone, let's say, that weighs 220 pounds. They can refuse the work. They can say, by lifting these bags of flour, I'm going to hurt myself and therefore I'm refusing the work. Resolution of stage one may just be moving that employee to a different part of the line where they're lifting 10 pounds. If that's the case, it's resolved and you can put another employee in. In other circumstances, you may have a work refusal where there's conflict whether or not the machine is safe, let's say. If you can't resolve the issue and there's no other worker to attend to it, you move to the next stage. In this case, stage three, where you involve the labor inspector. So that's a member of the government. You have to notify them. Here in Ontario, the Ministry of Labor. What they will do is they will investigate. They may do so through the phone. They may actually come on site and take a look at the area or machine or what have you. And then they will deliver a verdict. And again, you do not want to get to that point. So you want to resolve the issue before you get to this stage. The Ministry of Labor inspector, once they're in the work site, they're free to inspect. They're already there. They can look around and they'll look at other areas and see if it's safe or unsafe. They may also say, look, that machine's not safe, and take it out of order. And then the whole line or production area or what have you has to stop because that machine is unsafe. So how do you avoid this? Fix the problem before it becomes a bigger problem. So you need proper maintenance. You need to partner with good, safe clients that have maintenance programs in place, that have health and safety processes in place. You don't want to be getting into this stage. It's even more important for us to really monitor this if there is a case. So if someone does say, like, I don't want to work with that client anymore because of X, Y, and Z, you may want to have a process in place with the client to deal with that. If you don't, you have an absence of process there, and the person makes a complaint, the Ministry of Labor inspector is going to look at you as well. So they will look predominantly at the client. They may look at you as the temporary employment agency, who is the employer of record of that person. So just understand that. Okay, so those are the hazards. We're going to switch gear a little bit into provincial compensation acts. So this is the one, um, again, it's a very large piece of health and safety. Any of you that has had one of your employees injured, has been exposed to it. Purpose of today is just to kind of give you a high level overview of what to do when this happens. So employers, managers, supervisors, workers, and the government all have responsibilities when it comes to workplace health and safety. Additionally, workers have the rights to refuse unsafe work, which we've discussed, and know about dangers in the workplace. All of that comes into place when we're discussing workers' compensation. So what is, in this case, we're going to refer to the Workplace Safety and Insurance Act, which again is an Ontario specific name to the legislation. But what is it? It is an insurance plan to compensate employees who are injured or disabled due to workplace accidents. It ensures wherever possible the successful return to work of an employee during work-related injury or occupational illness. They also promote health and safety in the workplace and reduce injuries and disease. And they facilitate the return to work and recovery of workers. So, in a nutshell, what is it? One of the common beliefs in the public is that workers' comp is part of a bigger overall government program. It isn't and is. It is an arm's length agency of the government to handle this. All the um, funding for the program is by employers. What happens is employers report to the government, to the workers' compensation, what their insurable earnings are, and then they pay a percentage of money to the government. And that's to fund the workers' compensation board of their province. So the amount of money will depend on what sort of work it is. It'll depend on their previous health and safety experience in terms of like, have they been a good employer? Have they have a lot of injuries? Have they not handled those injuries well? It's also what's called a no-fault system. So employees are covered for injuries regardless of who's at fault. The workers' compensation, WSIB here in Ontario, they don't come in and investigate whether the employer is at fault or the employee. There is, as long as it meets the test that it is a compensable injury, they will cover the injury itself. There are strong financial and legal implications to workers' compensation. I was telling you, it is funded 100% by employers. So that means in general, it's a very costly line item for employers. It gets even more costly when there is an injury. So that's the financial aspect of it. Each Workers' Compensation Act has strong teeth to deal with employers and employees who are not cooperating. So an employer that is historically a bad actor and a very unsafe employer, what they're going to experience is much higher rates. So there's an incentive financially for an employer to be a safe employer, to deal with things, to have good maintenance programs, to have health and safety systems. And you do not want to be at the end of this government agency in non-compliance, because again, they can levy fines, they can greatly increase your costs. And if it gets serious enough, they'll call in the Ministry of Labor too, and it could potentially shut down the business. So we as employers have a strong financial incentive to participate in the program. We don't have a choice legally. We have to. There's no other insurance system allowed in most cases. And it means that it means a couple of things for us. So as an employer, it's a no-fault system, but it also provides coverage for the employees. What that means is the employee is covered, so they will receive wage replacement, they will receive health care and so forth till the point that they're able to return to regular duties. The protection it affords the employer is the employee, in most cases, cannot sue the employer. So the employee, by accepting the benefits of the Workers' Compensation Board, they agree to the terms of that arrangement. The employer is protected. They can't be sued further. The employee gets the wage replacement and expanded health care. So injury and loss of work. The Act ensures the employer receives support when they're returning to work in his or her pre-injury position or other suitable work. And that's important for our industry because it doesn't necessarily mean if someone's injured at one particular client that we can't move them to another client. We do have that ability in every jurisdiction in Canada to do that. They don't necessarily have to return to the pre-injury employer. They provide assistance in finding alternate employer if the injury prevents him or her continuing with the current employer. What that means if someone is seriously injured and let's say we as the agency can't find any more work for that person, the provincial compensation board will either retrain that person, they could send them to school, they could give them, computer classes, let's say, to be able to operate in the workforce, and they will charge you for it. So it does get expensive. Enables compensation to be paid to the worker when a worker loses earnings or becomes disabled. So what that means essentially is the worker, again, as a participant in the Workers' Compensation Board and Act, they will receive money and health care. So they're not going to lose their house because they have no coverage. It's not like some of the other countries, like the States, let's say, where there is no sort of financial safety net in place. Record keeping is critical. So when there is an injury in your workplace, you want to ensure that you're keeping records of everything that happens. You want to make sure that you understand the date and time of occurrence, names of witnesses, nature of injury, location of injury, details of any first aid treatment given. You want to get statements from any sort of witnesses that may occur. What happens is you want to treat it almost as as a police case. You want to find the who, what, where, when, and why, and get that information for a couple reasons. First being, you will have to report, depending on the nature of it, and we'll get into that, you will have to report it to the Workers' Compensation Board. And the other thing is claims can last a while. So you may not have witnesses available to you 6 months from now. You want to act quickly and you want to make sure that you are recording all the information. I had a teacher way back when he said, if it's not documented, it didn't happen. And what's a piece of documentation? It is a physical piece of information that whether a statement, pictures, you want to have documentation of the incident, or else the government, you can't just go on word of mouth. It will not assist you. Even if it doesn't seem serious, strong recommendation to document what happened. It could either become more serious later. So often in the case of humans, you may tweak your back or something at work and you push through it. And then 2 weeks later, you just can't work. You have to go to the hospital. You have to go to the doctor. It becomes worse. So you do want to have a mechanism in place. So even if it seems like a minor injury, you are recording it in your HRM, like whatever sort of system you have at your company. Even if it's just physical information, like recording on paper, make sure it's documented. If it's not documented, it didn't happen. Quick multiple choice. When there is a critical injury in the workplace, the manager is required to report the injury within 24 hours to 36 hours of the injury taking place to the safety group. 3 days to workers' compensation, immediately to the Ministry of Labor, 2 days with a written report to the Ministry of Labor, all the above, or B, C, and D only. Let's record your answers. It's a bit of a tricky one. Let's see what we have. So we got a few different answers. The best answer here is F. So again, it's a critical injury. So we have to report it for workers' compensation. We also have to immediately report it to the Ministry of Labor. And then we have to provide within 2 days a written report to the Ministry of Labor. Again, I caution you if you're in a different province, this is an Ontario process, but it is a very important piece of information to know. Reporting accidents. If an employee is absent from work or requires health care as a result of a workplace accident, the incident must be reported to the WCB within 3 days if your worker loses less time from work, your worker earns less than a regular day's pay, or your worker gets outside healthcare treatment. If there is no sort of, essentially, remember this, if they go to the doctor or they miss time, you have to report it to the Workers' Compensation Board. If they're able to do modified duties past 7 days or within 7 days and no medical is received and no lost time, you don't have to report it until you breach the 7 days. I would caution you against that. Just remember this thing. If they go to a medical professional, they miss time from work, you are to report it to the Workers' Compensation Board. I'll skip that slide. Return to work and duty to modified work. So when considering modified work, consider how it will support the injured worker. You have to make sure that it is achievable, safe, constructive, and productive. What does this mean? First off, what is modified work? Modified work is modifying the essential duties of the position to assist the worker as they recover from the injury. So that could mean a number of different things. It's a little more challenging for our industry because a lot of times we don't actually control the work environment. So you may have an employee that is at a client workplace and they are a general laborer and they injure themselves. You, as the employer of record, have to participate in modified work. So it could be working with the client to get work at the client. Oftentimes, what ends up happening is we have to bring the employee into our offices to perform modified duties. And we're bound to provide modified duties until the worker is able to return to basically the pre-injury work conditions. So what is modified work? again, you're modifying the essential duties of the position. It could be less weight, it could be less standing, you could give them a chair so they don't have to be on their feet. But they have some very specific sort of ideas behind it, pillars to what the process would be. Achievable is something where the worker is able to do it. So if the worker has an ankle injury, let's say, you can't have them walking up and down the aisles picking orders. They are not able to achieve that. Has to be safe. So if the worker is performing duties where they will likely injure themselves, those are not suitable modified work duties. Has to be constructive. That means, are you able to continue increasing the skill level of your worker? It also means it has to be something meaningful. So in conjunction with productive, you can't just have the person sitting there watching Netflix in the lunchroom for the entirety of their shift. Has to be achievable, safe, constructive, productive. Watching Netflix in the lunchroom is none of those things. Sure, it's safe. They can achieve it. It is neither constructive or productive. And so if the employee makes a complaint to the Workers' Compensation Board, you will be held in contempt for failing to uphold your duties under the return to work requirements. Just understand that. We're going to take a look at another case study. In a manufacturing plant, coworkers were unaware that an employee of 6 years was inside the oven when they loaded multiple carts, collectively containing about 12,000 pounds of tuna. They closed the door and started the oven. The victim inadvertently became trapped in the back of the superheated pressurized steam cooker. The process was 2 hours in duration and the temperatures rose to 270 degrees. This is an American case study. And the company faces a fine of up to $1.5 million if convicted. The reason this case study is part of the module today is because it does highlight the hazards that are omnipresent in the work environment. In this particular case, it was a fairly well-known manufacturer. The worker was not a new worker. They were there for 6 years. They were doing something that was very routine for their role, yet they still faced a workplace injury, ultimately a death, unfortunately. So this just highlights, that the hazards, again, omnipresent. We do want to ensure that we have processes in place. As a third-party provider of labor, we need to ensure that our client has these processes in place because we're not in direct care and control of the employees over the course of their workday. So just bringing that to your attention, make sure you have those processes in place. Make sure that you understand your legal requirements because the government will not, you can't just say, well, we're the agency, we didn't know. That does not apply to health and safety in any of our jurisdictions. We're gonna skip this section. As I understand, there's no one in Alberta today on the call. So at the back, you've all been provided this, the presentation. At the back are the links to the Provincial Compensation Boards of Canada. Even if you're in Ontario, some of the other compensation boards have really good information with regards to safety. BC is one of them. They spend a lot of money on videos and safe safe at work things. So if you're looking for some training items, definitely check them out. Check out the compensation board. Make sure you understand what your requirements as an employer within, if you're in Ontario, let's say Ontario, you go to the WSIB site, they will tell you what your responsibilities as an employer are. They will help guide you. They have some good education links for dealing with workers' compensation. As additional information, we have a few other links here. The CCOHS is a federal, I believe it's federal, but it's a safety resource that is invaluable. They do have information. So if you're looking at some just safety information with regards to specific roles you may have, so maybe you're not as familiar with, let's say, welding, you can go to the CCOH. 80% of their stuff is free. Again, it's a government sort of initiative, so it's sponsored by the government and industry. They have a lot of information, even if it's just to develop your job descriptions or make sure that you are recruiting and selecting people that have the necessary skills and abilities, and so that you can kind of understand those sort of roles. Ministry of Labor within your jurisdiction. And again, the WSIB has great roles if you look at the provincial boards. So any questions, please feel free to ask. After this, though, if you do have a question, you think about it later, you go back to your own workplace and think about, oh, one of the things I said, by all means, contact ACSESS. They will assist you as a member. They have resources available. And if not, they can guide you to, some good government resources that you may have. So not seeing any questions, I wish you luck on the CPC exam. With regards to health and safety, again, we went through a lot of information today. We did cover everything you will need for the test. And I wish each one of you good luck as you go through the CPC program. Thank you very much.
Thanks, Dave. Have a good afternoon.
Take
Thanks,
care.
Dave.